Welcome to this talk on competition law in challenging times. I'm Suzanne Rabb and I'm a barrister at Searle Court Chambers and I specialise in competition and EU law. As the United Kingdom enters the second month of lockdown, this talk will address how the UK and EU competition authorities have responded to the competition law challenges presented by the pandemic. The Competition Authority in the United Kingdom, the Competition and Markets Authority, has accepted that dealing with the pandemic may prove challenges for competition law enforcement, and it has adopted a targeted but focused relaxation of some areas of competition law. At the same time, this is not a free pass for businesses who flout the rules. The European Commission has initiated similar measures. And against the background of these developments, I'll consider the challenges and the risks presented by a more nuanced, risk-based approach to competition law, dealing with the outbreak of the pandemic and business cooperation that may be essential during these times. In part one, I'll address the response of the UK Competition and Markets Authority and some of the sector regulators who also have concurrent competition law powers. I'll then consider the response of the European Commission in applying EU competition law. The CMA has brought forth a number of measures ranging from procedural and institutional arrangements to substantive measures. Looking at the area of procedural enforcement, we can identify three broad streams: the creation of a COVID-19 task force, changes in the day-to-day operations of the CMA, and the impact on the ongoing flow of casework. So very early on in March, the CMA set up its own COVID-19 task force to equip the CMA with the challenges presented by the evolving competitive landscape and where developments were happening in real time. The task force mobilises the CMA to scrutinise market developments which may be harmful, such as price gouging and unwarranted claims about the efficacy of certain products. And the CMA has made it very clear that if firms are suspected of exploitation, such as charging unjustifiable prices or making misleading claims, it will investigate. An enforcement action will pursue if businesses do break the rules. And on an ongoing basis, the task force will equip the CMA to be prepared to advise the government on any emergency legislation that may be needed to deal with this situation. When we look to the day-to-day operations of the CMA, just like many businesses and public authorities around the world, their offices are closed, they're not accepting delivery of documents in the normal way, and staff are working from home. All of these measures happened very early on in March, showing that the CMA was agile to move to the challenges presented. All hearings are being conducted remotely using video conferencing technology. And resources are allocated to areas of most urgent and most critical need. The CMA's line is that mergers will be proceeding according to the normal administrative timetables. So, as distinct from the European Commission, they have not urged businesses to cease making merger notifications and to proceed in the normal course. However, the fact remains that in this environment, it will be more difficult to obtain information from third parties, which will inevitably hamper the process of merger review. In terms of the impact on ongoing cases, the CMA has a very busy caseload, and inevitably the increased demand for advice, consideration of new challenges presented, and particularly business cooperation, which we'll go on to discuss in the second half of this presentation, means that some important projects of the CMA are moving on a different timetable. So the CMA's digital task force, which was brought into force at the beginning of March, announced by the government on the 11th, will not be proceeding at the same pace, but remains nevertheless an important area of CMA policy. The CMA has also extended the statutory deadline for its funeral market investigation by 6 months, reflecting these unprecedented times and demands on that sector. Outside of the area of procedural and institutional changes, the CMA has brought forth a number of measures related to the substantive application of competition law, specifically the behavioural provisions under the Chapter 1 prohibition and the equivalent under EU law. So this has required a more targeted relaxation of competition law in some areas, essential business cooperation. The CMA has also issued guidance on its enforcement priorities and more detailed and focused guidance on its approach to the exemption criteria in what is the equivalent to Article 1013 of the treaty. So looking in more detail at targeted relaxation of competition law, and a number of measures of the CMA are influenced by a targeted and focused approach and recognition that cooperation between businesses at the horizontal level between competitors may be necessary. So it's allowed supermarkets to collaborate to feed the nation, essentially by sharing information on stock levels, cooperating to keep shops open, and sharing facilities such as distribution depots, delivery vans, and staff. And the need for that became very apparent in the early stages of the pandemic, where there were signs of consumers stockpiling various goods, and a response was needed to instill some more measure and rationality into that process. Healthcare providers have also been allowed to work together by sharing information, where the starting point would be in more normalised times that should be not an area of mutual cooperation between competing businesses. There's also been relaxation of competition law to allow ferry operators in the Isle of Wight to collaborate on routes and ensure continuity of services to ensure that essential supplies and freight are getting through. When it comes to enforcement authorities and priorities in this area, the CMA has recognised that a strict enforcement of competition law could impede necessary collaboration between businesses to deal with the crisis and ensure security of supplies. Assessing essential business cooperation under the Chapter 1 prohibition and Article 101 of the treaty can be fraught with difficulty, where the starting point is that there is a restriction and the consideration is whether that restriction is justified on efficiency grounds. And the CMA has set out detailed guidance on how it will prioritise enforcement cases and the application of the exemption conditions. So it's emphasised that cooperation would need to be efficiency enhancing, likely to benefit the consumer, reasonably necessary in the circumstances, and of a limited time duration because of the constraints of considering alternatives. So what we can take away from that is that some coordinated actions between competitors that will result in an avoidance of a shortage or to ensure continuity of supplies should be permitted. But this is very much an area where self-assessment and a risk call needs to be made, and there is no facility as such to seek an upfront approval with the CMA. So it's very much the familiar territory of a risk-based assessment in light of legal advice. In the area of merger control, as mentioned earlier, the CMA is working through its case law, and already we have seen an ability to adapt, to reflect on the challenges presented by the current environment and how that might cause a recalibration of the assessment of current mergers. So the Amazon Deliveroo merger was cleared provisionally on the 17th of April. And that's an interesting decision because in the CMA's announcement there, it acknowledged that absent the investment by Amazon, Deliveroo would have been forced to exit the market. And the CMA did note the deterioration in Deliveroo's revenues as a result of the fact that its key supply partners, such as restaurants, cafes, those businesses being forced to shut as a result of the pandemic and enforced social distancing measures, had a knock-on effect of Deliveroo's own revenues. The Takeaway Just Eat merger, which was cleared on the 23rd of April, is also an interesting insight into the way that the CMA will approach so-called flailing firms or failing firm type defences. In this instance, it's interesting that Takeaway, the acquirer, did have a presence in the UK market some years ago. So there had to be some consideration of the prospect of it re-entering. But in the context of this decision, the CMA acknowledged that there was no realistic prospect that it would have re-entered the supply of online food platforms absent this merger. So a very interesting insight into the CMA's analysis of mergers which are very much in the eye of the storm, in the sense that the business operational area is very much affected by social distancing measures. But at the same time, the CMA is very keen to emphasise that current situation is by no means a green light to allow anti-competitive mergers, and that there is a necessity to look very closely at the relevant counterfactual. That might not necessarily be the situation with or without this particular merger, but a modified counterfactual which looks at whether this acquisition is the least anti-competitive of the alternatives that are realistically available. Another aspect of competition law enforcement that is perhaps quite peculiar to the United Kingdom is the framework of competition law enforcement by the sector regulators and their concurrent competition authority powers, where they are able to apply the Chapter 1 and Chapter 2 prohibitions and Article 101, 102 in the areas that fall within their sector responsibilities. So already the Communications Authority, Ofcom, the Energy Regulator, Ofgem, have signalled that when it comes to compliance, they will take a pragmatic approach. A number of the sector regulators, in respect of their sector powers and competition law, have either suspended or delayed consultation deadlines and policy more day-to-day publications focus on some of the ongoing challenges with dealing with a regulated population as well as ad hoc competition law questions. The Water Regulatory Authority, Ofwat, has sent businesses directly to the parties that it regulates and is encouraging sector-wide responses, but within a proper risk-based assessment of the competition law risks. It's suspended its financial penalty regime for wholesalers and retailers that may be breaching industry standards. But again, emphasising that these measures will remain in place as long as they are necessary, and all regulators have signalled that this is by no means a free pass to businesses who may use the current environment to exploit consumers or make misleading claims as to how effective their products may be, or engage in price gouging. Looking to the European Commission, and let's remember that at least until the end of the year, which is the current transition period during which EU law continues to apply in the United Kingdom, subject to any extension that may be agreed to that, or any future trading relationships that may be concluded between the UK and the EU as part of a future trade deal, EU law remains applicable in the United Kingdom for the remaining 6 months or so. And responses by the European Commission have been somewhat similar to those of the United Kingdom, but with some more nuanced aspects. So the European Commission has brought forth exceptional antitrust guidelines for collaboration. It has brought forth a number of measures to deal with the influx of state aid notifications and questions that have been raised in the context of stimulus measures and financial support measures that member states have adopted to support their industries in these challenging times. And it has adopted special merger filing arrangements, which are more specific than the United Kingdom's more business as usual approach. So regarding the temporary framework for assessing antitrust issues, that was published on the 8th of April, very similar to the CMA's guidance regarding the Chapter 1 prohibition and equivalence, and emphasising that the CMA approach is to some extent replicated. The Commission will look at cooperation projects within a risk-based framework, recognising that some cooperation arrangements between competitors that would not be justified in more normalised times may nevertheless be compatible with Article 101 using a risk-based assessment. Interestingly, the Commission has set up an ad hoc procedure to provide comfort letters where appropriate to give business guidance with specific cooperation projects. Those competition law veterans who were advising in this area at least before 2004 when modernisation came into place, and I must confess I am one of those, will see some resemblance to the old comfort letter approach, where it was open to the Commission to issue a comfort letter where it was not prepared to give an individual exemption following a Form AB being submitted. So some resemblances to that. I doubt very much that this is a return to that world where modernisation's whole aim was to apply a more risk-based approach where businesses would do their own self-assessment. but it will be interesting to see how much use is made of that procedure. And again, it is by no means a complete safeguard and approval of that business practice, but as it says, a comfort letter to give business some comfort going forwards in embarking on cooperation, which would normally raise competition issues. Regarding state aid, again, the measures that the Commission has been faced with bear some resemblance to the increasing amount of state support in the wake of the financial crisis in 2008. The topic of state aid is subject to a more focused webinar on this particular subject, which is available at silcourt.co.uk, and details are provided with this link. But as early as the 12th of March, the Commission approved its first notification measure, €12 million worth of compensation in Denmark to businesses affected by cancellations due to social distancing measures, which made large-scale public events impossible. This was approved in 24 hours, showing remarkable agility, and a number of other notifications and approvals have followed in short order. The Commission used Article 107(2)(b) of the treaty in approving this particular measure, and this allows Member States to compensate for the damage directly caused by exceptional occurrences. Interestingly, the pandemic is not treated as a natural disaster, which may be subject to exemption under the general block exemption regulation, and it was that made an individual notification necessary. The Commission has also adopted a temporary framework for state aid. The first version of this was published on the 19th of March, and there have been further refinements which allow a range of support measures from direct grants to state guarantees. The Commission has also been faced with pleas from some member state governments, including Austria, to completely stall the state aid enforcement system during the context of the pandemic. That plea has been resisted. Perhaps not surprisingly so, similar pleas were made during the 2008 crisis. Austria made the claim that the administrative burden of notification for measures that do not fall within the temporary framework or other block exemptions may result in delays in aid being granted and implemented. In defence of that, it's been said that any delays that may have been experienced in other times have not been the fault of the Commission, but the fault of implementation at the national level. So far, the call for a much wider blanket suspension of state aid rules has not been accepted. It will be interesting to see how, when the UK's own subsidy control regime takes effect at the end of the transition period, which is expected to be at the end of the year, how a homegrown state aid or subsidy control regime, to use a neutral term, will respond to similar requests. But that's very much a watch this space area. When it comes to merger filing arrangements, the European Commission, unlike the Competition and Markets Authority, has urged parties to delay making filings. It has identified complexities and disruptions and asked businesses if they can delay making filings until further notice. That does need to be seen in the context of a mandatory regime in Europe, where mergers that amount to a concentration with a union dimension do need to be notified and usually suspended until they are approved by the Commission. That is unlike the position in the United Kingdom, where merger control informing the CMA is voluntary, albeit businesses take the risk of an investigation and referral within 4 months of the business ceasing to be distinct or the material facts coming to the attention of the CMA. So the European Commission is faced with a different procedural dynamic there. So it has emphasised that it does remain open to dealing with urgent notifications, but at the same time has been very realistic in identifying to parties that they may expect problems when collecting information from third parties as part of a market test. So to draw some conclusions here in what is inevitably an evolving landscape, and just this week there have been more measures by the European Commission in respect of targeted relaxation of competition law in areas of essential business cooperation, particularly the food industry. So we've seen that the pandemic has necessitated a more nuanced approach to competition law, but at the same time toughening up in some areas, particularly abuse of dominance, where the pandemic is no excuse for price increasing, where businesses may be able to withhold supplies and distort demand patterns. And any relaxation of the rules is very much partial, temporary and narrow, and justified only where necessary. Very much not a free pass for businesses that are found to have shut off supply chains or exploited vulnerable consumers. So we do see some similar approaches by both the UK Competition and Markets Authority, the regulators with concurrent competition powers, and the European Commission, but also reflecting their different procedural contexts and the fact that they have slightly different responsibilities. The CMA, consumer welfare, the concurrent regulators have also their sector regulatory responsibilities, and the European Commission facing mandatory merger control and a state aid notification regime where it has to approve individual state aid notifications unless an exemption or framework is in force. This is a challenging time for all businesses, regulators and their advisors, and will involve some serious stress testing of business efficiencies and business models. Inevitably, some businesses will go to the wall, and the relaxation of competition law is by no means an excuse or an area to focus on to justify practices which are anti-competitive. But we are very much in evolving times requiring a creative risk assessment. So perhaps now more than ever, it's important to take a risk-based approach to business cooperation and fully understand that the approach of the competition authorities in this area is evolving in real time and requires careful consideration. If you'd like to learn more about this area, please don't hesitate to get in contact with me, Suzanne Rabb, at Searle Court Chambers, and I'd be happy to discuss with you further. Suggestions for any further webinars or talks on competition law and regulation are very much welcome, and indeed this talk itself was prompted by comments on the previous video on state aid. Thank you very much.